Edit that out, Yosh. Okay. Okay, I wanted to go over some basic ideas on asset protection. You're going to hear stuff that you probably have never heard before. I am not a total, here's the positive, I'm going to sell it to you kind of attorney. I'm going to give you both sides. I'm going to give you the positive and the negatives. Okay, you're going to learn a lot. First, there's no such thing as bulletproof. And I have a real problem with lawyers who say this is your bulletproof asset protection package. So it's not true. It's not a true claim. Nothing is bulletproof. And then they'll go on and say, oh, well, as long as you maintain it, as long as you do the corporate governance, and they kind of downplay that, because they want to sell to you. But there's nothing that's bulletproof. I can create the best structure. We can run it the best way possible. We can create the biggest stack of evidence we can and do everything we can. And it's still possible that it may not work. I mean, that's just always a possibility. My goal is to educate you to the best of my ability, create the biggest, strongest case we can, and that's really what we can do. Our laws in the U.S. are actually designed to force you to pay your debts. Right? Our laws aren't designed to let you escape liability. In fact, the reverse is true. They are designed to force you to pay your debt and pay damages if you injure somebody. So in asset protection, you're actually working against the way the laws are written. Okay? Different liabilities require different solutions. That's why we're going to talk about over a dozen different strategies. Tax planning, estate planning, corporate maintenance, asset protections can be at odds. You're going to see that tonight. You may go to an estate planning attorney who's going to set up a family living trust for you and want to put all your assets into the trust, which is great for estate planning purposes. But it may not be the most protection you're going to get. In fact, there's no protection at all in a family trust. So if you want to protect your assets, you want to get things kind of out of your family trust. So they're at odds, and you need to understand that they are at odds sometimes, and sometimes what might save you on taxes may not be the best for asset protection or estate planning. So you kind of have to make a balance, learn all you can about all these different strategies, and then balance out what works for you. The more protection you want, the more complicated / expensive your life becomes. You're going to see that tonight. We're going to start from very simple and basic to very complex structures. And the more complex it is true, the more protection you're going to get. It's also going to be a lot more expensive and a lot more work. Maintenance of your structure is just as important as structure yourself. You'll see that tonight. The LLCs and partnerships that we'll talk about tonight are used for protection. Land trusts, we're going to talk a little bit about that tonight. They're used for privacy. There's no protection in a land trust. Family trusts are used for estate planning purposes. So these terms get thrown out a lot, and they're often confused. And people are like, well, I've got a trust set up. Is that my family trust? No, and when I look at it, I'm like, no, that's your land trust, your whole title to real estate, and that's not a family estate planning trust. So, wow. From where? Were you in Rose Park looking for homes? Oh. Otherwise, you wouldn't have showed up if you weren't downtown.
Of course, I come to learn from anyone more smart than I am.
There you go. I'm more smarter. I'm more smarter than Matt. Okay. A simple combination of protection, privacy, and insurance is generally the best option. I always, I don't say just do this one thing. Have insurance. Do what you can to remain private. Get the right corporate structure, and then run it to the best of your ability. Okay? Cover your bases, right? Build the strongest case you can. And all the tools we're going to talk about tonight can be used in different situations. And we're going to go over 14 different arrangements, but in fact, you can combine these in probably over 100 different ways, just using the different tools. My job tonight is to teach you the tools tonight. It's only 2:45. It's not tonight. It's today. It's this afternoon. It's a beautiful afternoon. We are going to get more Irish car bombs. There's plenty of liquor left over. Okay. Now, I'm going to briefly cover some liability and protections that I normally teach in a 2 to 3 hour class. I usually teach an hour class on liability, an hour class on basic protection, and an hour class on corporate governance. We're going to cover those really quickly. This is an advanced class today. But I've taught those classes. They've been video recorded. They are available on my website. So you can go to the website, go to the video courses page, and review to your heart's content. Watch them over and over and over. There's over 10 hours of education there. And, of course, the free webinars during the course of the year, I will cover this as well. In fact, April's is on liability. So if this goes a little bit over your head, don't worry. There are resources to kind of help you out. There are two kinds of liability that you face. One is personal, the other is professional. The great example of personal liability is danger you run into by being a human being on this planet and in this country. Okay? If you drive your car and you get into a car accident and you injure somebody, you yourself as an individual caused that damage. Okay? Therefore, that is personal liability. Okay? It's liability that attaches to you as an individual. Professional liability is a liability that you run into in your professional life. If you own a grocery store, someone comes into your grocery store, slips on a banana peel, okay, breaks their arm, breaks their neck, becomes paralyzed. That was part of what you do as a profession. And if it's personal liability, since it attaches to you as an individual, they sue you, right, the individual. If it's in your business, they sue the business, okay? So those are the two basic types of liability. Either it's personal or professional, and you need to know that because there are two kinds of protections that you get. Where's Yosh? Did he take off? Just wondering how far out of the camera range I can go. There are two kinds of protections you get. One protects against that personal liability. The other protects against that professional liability. Almost everybody that I talk to that hasn't really studied this doesn't even know these two things exist. Because I hear, I'll get a phone call and say, oh, I just went to this seminar and I was told that single member LLCs have no protection. No, that's not true. They do have protection. They have one of the kinds of protection, but they don't have the other kind. So we need to understand what we're talking about so that we're all on the same page. There is something called, we're going to start with this one, corporate veil protection. Who's ever heard of the corporate veil? Right? This is the protection that most people understand and recognize. This protects your personal assets from your professional liability. Okay? So here's the professional. This is the slip and fall in your grocery store. This would be a tenant who falls downstairs or off the balcony. Something that happens within your business and that you got hurt by it. This corporate veil creates a layer, a protection, essentially a shield between this liability attaching to your personal assets. So your tenant is going to sue your company, and your personal home, your personal savings accounts, your cars, your other assets are protected because of this corporate veil protection. That is a great protection, right? Now, any of the assets in the company are at risk. Okay, you could lose your corporate savings account, you could lose corporate assets, inventory, whatever it is, but your personal assets are protected from your professional life. So it separates personal from professional. This is true of any entity, corporation, limited liability company, family partnership, okay? All get that. Well, family partnership, there's a caveat to that, but we'll get to that. This is the one that most people don't know about. This is called charging order protection. This works in the opposite direction and protects different things. This protects your business assets and even some personal assets if you stick them in the right place from your personal liability. So this is a situation if you're in a car accident. Oh, FYI, take all the notes. You will all get a PDF of the PowerPoint on Monday or Tuesday, and this entire thing is being recorded and available on the website. Okay? So we're going to go through a lot of diagrams, lots of pictures. You don't need to copy all the pictures down. You will get the PDFs of all this. So take notes as you need. You'll get these copies. And so if you're driving down the highway, you hit a bus of children, you kill 30 kids, and you're sued for $500 million. Okay? That, since it's personal liability, it's going to be, they're going to sue you as an individual and try and get after anything you own, right? Well, this charging order protection can protect assets that sit in these entities from a court attaching to those assets. We're going to talk a little bit more about that later when we talk about the family limited partnership and where it comes from. And so I just want to bring up now that this charging order protection is different than corporate veil protection. Okay? And we're going to talk about when each apply. In asset protection, you want both, if at all possible. You want to get both. Okay? Sometimes you're only going to get one. That's okay. But just understand what you're doing. This is education. This is to teach you what is what. Okay? So we have two kinds of liabilities and two kinds of protections. Be aware of that. It'll become clear as we use examples. Okay? Single member versus multi-member LLCs. This is an important distinction that a lot of people don't realize. A single member LLC gets no charging order protection in the state of Utah. Okay? There are some states that by statute give this special charging order protection to single-member LLCs. We don't know exactly how strong that is. There are there was one real case and a couple of other cases where in the state where there was charging order protection for a single-member LLC, the court, and it was a bankruptcy court, and bankruptcy courts are federal, and federal bankruptcy courts have a lot of power. They're generally better at piercing things than just a lawsuit from somebody that sues you for damages. And those courts said that, you know what, we're not going to give discharging order protection to a single-member LLC. And they actually ignored what the state legislature wrote in statute. And now the theory is that a lot of these states that want to provide this protection to single-member LLCs will revise their statutes to kind of strengthen them and see if they can make it happen. But in the state of Utah, for whatever reason, our legislature decided to exempt single-member LLCs from this protection. I mean, it's literally in the statute. It says single-member LLCs don't get this. Now, the reason being, the background on discharging order protection and the single versus multi-member. It originates from partnership law, okay? Let's say Matt and I have a partnership, and we buy houses, and we've got a partnership together where we own 10 rental properties, okay? And we own them free and clear, and we have about $1 million in assets in this partnership with Matt and I. Matt goes out drunk driving and kills a bunch of people, and because I don't drunk drive. That's right, Matt has a driver. And so Matt's going to get sued, right? That's personal liability. Now, the court's going to look at Matt and go, whoa, Matt, you've got tons of assets, okay? You've got this partnership with Jeff, and you've got $1 million. We want that $1 million to pay off the families of these kids that were killed, okay? Now, if the court were able to reach into that partnership and take our 10 homes to pay that judgment, who got screwed? Me, right? I don't care about Matt anymore. If you're going to go on drunk drive and kill people, that's your business, and if you lose everything, that's your business, right? But I didn't do anything wrong, and I own half these homes. So to liquidate these homes, I would lose assets for the next 20 years, income for the next 20 years, And so courts, even though they want to force you to pay your debts, they're also very fair. And it's not fair to me, the partner, to lose my assets because of his problems. So what the court said is, we're going to only give charging order to the plaintiffs in this case. What does that mean? That means we're not going to force the partnership to sell off the assets. They're protected. They're going to stay in that partnership as long as we want them to stay in, keep collecting rents, let the equity grow, we're all good. The creditors, or the plaintiffs in the case, are going to get whatever Matt would have gotten from the partnership. So if I make a distribution, right, we take the rent, so we flow, let's say, $1,000 a month positive. I would get $500, Matt would get $500, right? That $500 is not going to go to Matt. It's going to go to his creditors. I get mine because I'm the innocent party, but Matt's half is going to go to his creditors. And that's a charging order. So they get what Matt would have gotten. Now, as a partnership, since I'm going to be the managing partner, since he's an idiot, I'm going to decide not to make distributions. We're just going to keep it in the partnership. We're going to keep it in the company, right? So this creditor, whatever of Matt's, it gets these rights to this money, is not going to get it because we're not going to distribute anything. So they're going to sit around for years and years and years and years waiting to get some distribution, okay? That kind of sucks for them, and that's not an incentive to kind of go after. A question is so I'll remember that. The other thing that's going to happen is at the end of the year, our partnership has to issue a partnership tax return and K-1s to the members, right? And tell the IRS how much each member made that year, even though we don't give the money out. So the creditors of Matt are going to get a tax liability. They're going to get a K-1 statement that would have gone to Matt, and so his creditors are going to have to pay taxes on the money that he would have gotten but didn't get, neither did they. So this charging order protection is really a great tool because it's not a real big incentive for somebody to go after these assets and wait around for 20 years paying taxes on money they're not getting. Okay? So that's charging order, and it comes from protecting the innocent partner. That's why single-member LLCs are a little suspect with this charging order protection. Because who are you going to protect in a single-member company? There's nobody to protect. There's no innocent partner. Okay? That's why Utah is probably, from a statute standpoint, exempted single-member LLCs. And even in the states where they're giving this protection to single-member LLCs, the courts aren't real happy to honor that, because the whole point of charging order protection is to protect the innocent partner. And so why, if I'm the only owner of this company and I'm the one that got into the car accident and killed people, why should these assets be protected when I'm the liable party and I need to pay, the damages? So we're going to see where that goes. We're going to see if states can actually beef up their statutes and if they'll start getting this protection. But for now, I wouldn't count on it. And of course, in Utah, don't count on it at all. So that's why we were going to make a big distinction between single-member and multi-member LLCs and entities during the course of this afternoon, because of this charging order protection is not available to the single members. Now, the nice thing about the single-member LLC is that it doesn't file a tax return. That's why everybody likes the single-member LLC. It's a flow-through entity. It doesn't file a tax return. It's a whole lot easier for bookkeeping and tax preparation. Okay, that's convenience. Multi-member, yes, you must file a tax return. Okay, so there's additional work involved. Now, the question becomes husband and wife. Are husband and wife considered partners, or are they considered a single person? There's a little bit of discrepancy there. There is one case in Florida where a husband and wife were ruled as a single individual. And the court said, you know what, they're married, we're going to treat them as a single individual, and there's going to be no charging order protection. One case, there are other facts in that case that I think that led the court to that decision. My recommendation is that a husband and wife, particularly in the state of Utah, will be treated as partners as long as they treat themselves as partners. Okay? In Utah, because we're not a common property state, in a common property state, husband and wives are considered a single individual by the IRS. So you've got a big government agency calling a husband and wife a single individual. But in a non-common property state, the IRS considers a husband and wife partners. So if you have an LLC owned by you and your spouse and you're legally married, okay, you should be filing a partnership tax return and issuing K-1s to each spouse, even though you file your taxes jointly. Okay? Because the IRS considers you a partnership. And if the IRS considers you partnership, that's pretty strong weight to go into court and say, we are a partnership. But you got to, I'll say this repeatedly during the day. That looks like a duck, quacks like a duck, and walks like a duck, guess what? It's a duck. Okay? If you treat yourselves like partners, you act like partners, you talk like partners, you're going to be partners. But if you act like a single individual, walk like a single individual, and quack like a single individual, you're going to be treated as a single individual. Okay? It's all about how you run the company. Okay, do you have a question you just raised? Oh, yeah, sorry. Thank you. The charging order is a court order, so it is public record, and it absolutely can, I would assume, hurt your chances of getting a loan. It's a liability, it's a debt, and it's a court order judgment is what it is. It's just that the judgment gets paid out as the partnership would pay out distributions. But it is a debt. It's like having a big debt hanging over your head. On the asset? Could be, yep. The charging order would always be filed against the individual. Yes, because it's personal liability in the first place. Now, I suppose you could have an entity own an entity, and the entity did something. Yeah, I mean, if it's so if you and I, yeah. You and I own this 10 boards together. And our partnership were owned by our. Your partnership was White Polo LLC owned the entity together with me. Right. Green Shirt LLC. If they sued us, they sued our entity together, and then they sued White Polo. They sued Green Shirt LLC. If Green Shirt LLC ran the liability in a professional sense, you did.